Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in.
Okay, guys, we're going to end this live. I will restart it later. This live. Thank you, Rodney. Thank you for Rodney. Hello.
Well, guys, we got Karen Reed the moment we left. So here we're just going to jump straight on into her hearing. Sorry about that confusion, guys, but it is what it is. But thank you so much, Ronnie. Let's go into the Karen Reed. Since introducing the case against Karen Reed, issuing instructions to prospective jurors. Y'all, this is the bigger courtroom, I believe. Welcome back.
Can the court please stand? Hey. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. Jurors remain standing. Everyone else may be seated.
I'm sorry, jurors, could either of you all raise your right hands, please? Do each of you solemnly swear to make true answers to such questions that should be put forth to you by the court, so help you God? Thank you. You can have a seat now, promise. May I call the case, Your Honor?
Yes.
Your Honor, this is 22-117, the Commonwealth versus Karen Reed.
Counsel.
You want counsel? You want me to say?
Counsel.
Could I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson on behalf of Karen Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George on behalf of Ms. Reed.
Good morning, Ms. George. Good morning, Ms. Reed. Okay,
Karen Reed,
Jen.
can you please
That was
stand?
the juror.
Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to anything, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
Okay, good morning, jurors. My name is Beverly Canoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on what you will be asked to do. So, jury service, as you know, is one of the most important duties we have as citizens. We appreciate that you're here, ready, willing, and able to serve if you're called upon to do so, and our system of justice simply does not work without you, so we thank you. This is the case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29th, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. So Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and with leaving the scene after causing personal injury or death. I will describe these indictments in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in greater detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while the public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask you questions all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you are not selected for jury service on this case, you should not take it personally. Don't think that somehow you're not a fair person, because it's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for another case. In a few minutes, I'll pose a number of questions to you as a group. You have just taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer can read the number from the card. You don't have to get your cards out yet. I'll tell you when it's time to get your cards out. Now, the fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that counsel and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer the question at sidebar. I may have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror in this case. And the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer to any question. We're simply looking for your honest and best answers to the questions. Now I'm going to have the lawyers introduce themselves. We'll start with the Commonwealth, and when the defense introduces themselves, please introduce your client. Mr. Brennan,
Your Honor.
please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me are two other attorneys I'd like to introduce you to. All the way to my right is attorney Laura McLaughlin. And next to me is attorney Adam Lally.
Thank you. Defense counsel, please.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the privilege of representing Ms. Karen Reed, who is to my right.
Good morning, members of the jury. My name is Elizabeth Little, and I also have the privilege of representing you.
Good morning, ladies and gentlemen of the jury. My name is Robert Alessi, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston. I also have an office in Dedham. It's my privilege to represent Karen Reed.
Good morning, members of the jury. My name is Victoria George, and I have the pleasure of representing Ms. Reed.
Good morning, Karen Reed. Thank you for being here.
All right, thank you very much. Folks, I'm going to read a very lengthy witness list to you. It's important that you listen to the names because at some point I'm going to ask you whether you know any of these folks. So when you hear it, please listen to it in those terms. Now, it does not mean that all 150 witnesses are going to be called at trial, but you'll hear their names if they're not called. You may hear their names during trial. So it's important that we know if you know these folks. The list is alphabetical, but it's alphabetical by first name. So Aidan Kearney from Jefferson, Mass. Dr. Aziz Wolf from South Miami, Florida. Alfredo Lopelato from Canton. Allison McCabe, also Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, PhD from Pittsburgh. Angela Malvone from Canton. Annie Chung from Canton. Anthony Flamati from the Canton Fire Department. Ashley Bell from Canton. Ashley Valliere from the Massachusetts State Police Crime Lab. Brian Albert from Norwood. Brian Albert Jr. from Boston. Brian Higgins from Sandwich. Brian Loughran from Canton. Brian Wanless, retired Canton Police Department. Bridget Meehan, keeper of the records in Canton. Caitlin Albert.
Guys, I gotta tell you this, guys. My boo, my honey boo over here, told me at a quick glance it looked like her cup was flicking the people off. I looked at it and I went, "Yep, that kind of does look like a." Oh, this is gonna be fun, y'all.
From Easton. Charles Ray, a lieutenant with the Canton Police Department. Chief of Police of Canton, Helena Rafferty. Chris Van E., PhD from Novi, Michigan. Christina Hanley from the Massachusetts State Police, Christopher Albert, Canton, Christopher Curran, Canton, Colleen Crawford from the Norfolk County District Attorney's Office in Canton, Colin Albert from Canton, Courtney Proctor from Canton, Kurt Roberts from Canton, Daniel Whitley from the Canton Fire Department, Daniel Wolf, PhD from Penns Park, Pennsylvania, Derek Ellington from Wake Forest, North Carolina, Dr. Marie Russell from Los Angeles, Dr. Elizabeth La Posada from Providence, Elizabeth Proctor from Canton, Eric Hanlon, Canton, Erin Beatty, Canton, Erin O'Keefe, West Bridgewater, Francis Walsh from the Canton Fire Department, Garen Wing from Green Cove Springs, Florida, Gary Fowler from Brockton, Gregory Woodbury from the Canton Fire Department, Gretchen Voss, Boston, Mass, Hannah Knowles from the Massachusetts State Police Crime Lab,
Didn't they move out of the house and sell it and move to a neighboring town?
Heather Maxon from Walpole, Arabito Hernandez from the Boston Police Department, Holly Price from Mountain View, California, Ian Whiffen from Vienna, Virginia, Dr. Irene Scortibello from the Office of the Chief Medical Examiner in Massachusetts, James Crosby, Master's PhD, from Jacksonville, Florida, Jason Becker from the Canton Fire Department, Jean DeMulis from Canton, Jennifer McCabe, also Canton, Jessica Hyde from Bridgeport, New York, John O'Keefe Sr. from Braintree, Judson Welcher, PhD, from a company called Aperture, LLC, Julie Albert from Canton, Julie Nagel from Canton, Dr. Justin Rice from South Weymouth. There's a juvenile whose initials are KF from Canton, and there's another juvenile whose initials are PF, also from Canton. Caitlin Boudreau from Raynham, Karina Kolakithis from Canton, Katie Camerano, also Canton, Katie McLaughlin from the Canton Fire Department, Keeper of the Records for Ring from Hawthorne, California, Kerry Curran from Canton, Kerry Roberts, Canton, Kevin Albert, Canton, Kevin O'Hara from the Massachusetts State Police, Lance Mello from the Massachusetts State Police Crime Lab, Laura Sullivan from Pembroke, Laurie Cahill from Worcester, Leslie Pearlstein from Canton, Lieutenant Michael Lank from the Canton Police Department, Louis Jutras from Canton, Lieutenant Brian Tully from the Mass State Police, Lieutenant John Fanning from the Mass State Police, Lieutenant Paul Gallagher from the Canton Police, Maggie Gaffney from Bonita Springs, Florida, Mark Lopalato, from Canton, Margaret O'Keefe from Canton, Marietta Sullivan from Pembroke, Mary Souza, Dighton, Matthew Amory from Canton, Matthew DeSogra from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly, Canton Fire Department, Matthew Kelsch, the Federal Bureau of Investigations, Matthew McCabe from Canton, Maureen Harnett from the Mass State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano from Canton, Michael Easter from Los Angeles, California, Michael Trotter, Canton Public Works Department, Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Wyweek Berschneider from San Marino, California, Nathan Reed from Raynham, Nicholas Bradford from Lorton, Virginia, Nicholas Curran from West Roxbury, Nicholas Kolakithis from Canton, Nicole Albert from Norwood, Norfolk County District Attorney Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barrows from the Dighton Police Department, Patrick Haggerty from Somerset, Paul Mikowski from Melrose, Paul O'Keefe from Canton, Rebecca Bison from Canton, Rebecca Treyers from Norfolk, Mass, Dr. Renee Stonebridge from the Office of the Chief Medical Examiner's Office in Boston, Richard Green from St. Beach, Florida, Richard Donatino from Canton, Robert Gilman from Hull, Ryan Nagel from Canton, Sarah Levinson from Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul Giampietro from the Canton Police Department, Sergeant Yuri Buchanan from Massachusetts State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh from Canton, Sophie Herzan from the Mass State Police Crime Lab, Stephanie Devlin from the Mass State Police Crime Lab, Stephen Mullaney from the Canton Police Department, Steve Nelson from the Norfolk DA's office, Steve Bernstein, who is a keeper of the records in Stoughton, Stephen Ridge from the Boston Police Department, Stephen Saraf from the Canton Police Department, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty, Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton, Trooper Connor Key for the Mass State Police, also from the Mass State Police, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Kostowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robery from Canton, William Reed from North Dayton. That's the list of witnesses, folks. So in a while, I'm going to ask you all if you know any of those folks. So as you can imagine, this case is expected to take a while. The lawyers tell me that once we get a jury, which may also take a while, once we get a jury, that it's estimated that the evidence in this case should take 6 to 8 weeks. We do our best to let you know in advance what we anticipate the length of trial will be. When we start the trial, we will go full days so that we can expedite the trial. The dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half expedite the trial.
I thought you said
the dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock. Or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half days throughout the schedule. So that's the schedule that we intend to keep. Now, it might help you if I give you a preview right now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal principles that govern the trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring her to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, "You accuse me, now you prove it, and prove it beyond a reasonable doubt. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in
No, that's not important. Do you know why? I've already deemed her guilty. I'm going to do everything I can to prove her guilt.
their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before the jury in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. A juror's job is to find the facts. In determining the facts, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and circumstantial evidence. I'll define those terms in greater detail later, but direct evidence essentially is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, I've used the word inference. An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one which is not too remote in the ordinary course of events. You may not guess, you may not speculate or engage in surmise. When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, obviously, as everyone else. So let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of on unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So for jury selection, it's important to know if any of you might have doubts whether you can accept and follow these legal rules. So I'm going to ask you questions in a few minutes. So if your answer is yes to any of my questions, please raise your hand. Before we begin, though, I understand that sometimes jurors do not fill out the juror questionnaires completely, that sometimes we are in a rush to send them in, or sometimes we don't think that our situation applies to the question that is asked. If the lawyers and I notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us. Also, if you know now that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether as a party in a case, a witness, or a juror, please let us know. So while you're taking out your cards, I will see counsel and Chief Rosen, juror number 79 too, and counsel at sidebar, please.
Okay, guys, I need somebody good with Excel. I am about ready to put my fist through the screen. I have the updated list. I have a list of, I have a list for the prosecution for witnesses, a list for the defense for witnesses in Excel. I can't, they have like 80, 90 to 100 people on the respective. And then I have a list, a final list from the combined list of witnesses. I need that combined list of witnesses put in Excel. Ronnie, there is a list and that was downloaded, I think yesterday, the final list with 150 people on it. That is a combined list. Ronnie, can you look at that combined list and then put it in an Excel spreadsheet with what you have? I need a master list if possible. I hate Excel. I can't add a column or row. No, don't turn around, Gerald. No, don't turn around. Just go on, boo. It's something that one of my mods can handle. You don't need to turn around. But I can't copy and paste. You've already done it? Oh my God, Ronnie, you're amazing. I can't copy and paste out of that document. So that's why I'm like, Arr! Don't worry, Gerald. We got it. My Ronnie's on it. She's amazing. Ronnie, you are simply Simply the best. Go ahead and put it in Karen Reed Docs. Better than all the rest. You're amazing, Ronnie Boo. I like you, Ronnie. You've always been there for me, and you're really good at this. I am not. I will learn Excel when my brain is capable. My brain ain't capable right now. I got college, I got this, nah. My brain doesn't want to work that way. You're good, honey. Keep going. My honey left. He went back to where he lives 2 hours away.
So now I have questions that I'm going to ask you, and the court officers will read your number. So if you have that card, and hold it high, please. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read? Please raise your hand.
96, 96, 32, 32, 59, 59, 3, number 3, number 83, 83.
Juror number 46, 46.
Juror number 90, 90.
All right, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or with the Norfolk County District Attorney's Office? I see no affirmative responses. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. Has anyone seen, heard, or talked about this case? Please raise your hand.
Juror number 47, 47. Juror number 108,
You're
108. Juror number
amazing.
54,
You
5.
are amazing, Ronnie. We love you, Ronnie. You're simply
Juror
the best.
number 95, 95. Juror number 12, 12. Juror number 35, 35.
Well, when you add the 7 people, send it to me again.
107. Juror number 41, 41.
Yeah, please send it to me again if you
46.
add the people.
Juror number 24, 24. Juror number 97, 97. Juror number 23, 23. Juror number 99, 99.
Juror number 25, 25. Juror number 90, 90. Juror number 92, 92. Juror number 91, 91. Juror 106. Juror number 101.
Now it resides on my desktop. So if you change that, just send it.
Juror number
It's a good start. So when you get that other fix,
Juror number
let me know. Just send it again.
Juror number 60. Juror number 115, 115. Juror number 76. Juror number 66. Juror number 85.
Juror number 57, 57, juror number 6, juror number 96, 96, juror 109, juror 113, 13, juror 73, 73,
There's no captioning, y'all.
juror 31, 31, juror 32, 32, juror 111, 111, juror 88, juror 53, 53, juror 110, juror 59, 59, juror 40, 40, juror 94, 94, juror 3, juror 86, 86, and juror 62, 62, juror 84, 84, juror 112, 112, juror 64, 64, juror 82, 82, juror 19, 19, juror 77, Juror 17, 17. Juror number 75, 75. Juror number 38. Juror number 43. Juror number 29. Juror number 87. Juror number 28. Juror number 56. Juror number 113. Juror number 36. Juror number 98. Juror number 83. Juror number 72. Juror number 24. Juror number 42. Juror number 78. Juror number 18. Juror number 67. Juror number 37. Juror number 69. Juror number 63. And juror number 22.
Juror number 30, 30. Juror number 45, 45.
Don't get the jury.
Okay, thank you. Have any of you folks expressed or formed any opinion with respect to this case? If so, please raise your hand.
Juror number 108, 108. Juror number 7. Juror number 95, 95. Juror number 107, 107. Juror number 2. Juror number 35, 35. Juror number 8. Juror number 97, 97.
Juror number 90, 90. Juror number 91. Juror 106.
That's 10.
Juror 101. Juror 105. Juror 60. Juror 115, 115. Juror number 66. Juror number 85.
Juror 109. Juror 73, 73. Juror 86. Juror 3. Juror 94. Juror
20.
40. Juror 59. Juror 53. Juror 84. Juror 112, 112. Juror 64. Juror 82. Juror 77. Juror 17, 17. Juror number 75. Juror number 43. Juror number
30.
29. Juror number 28. Juror number 113. Juror number 36. Juror number 18. Juror number 37. And juror number 22.
All right, thank you.
38.
Are any of you folks aware of any bias or prejudice that you may have in
Oh.
regard to this case or in favor of or against either of the parties? If you believe that you might have a bias, please raise your hand.
That's 38.
Juror number 25. Juror number 8. Juror 90. Juror 91. Juror 101. Juror 105. Juror 65. Juror number 60. Juror number 115, 115. Juror number 66. Juror number 85.
Juror number 17. Juror number 38. Juror number 36. Juror number 37. Juror number 2.
All right, thank you.
17 out of 30.
Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict?
You just broke the ADL law. If I'm deaf, you provide a court interpreter. You can't hold that against me. And she just grouped me in with people who are not able to mental capacity. But I'm deaf. I need an interpreter. That's all I need. And I can do my job as a juror. So that pisses me off.
If so, please raise your hand.
Juror number 95, 95. Juror number 8.
Juror 101, 101. Juror number 65.
We are missing we are missing a ton of subs. We lost almost 60 subs. Just disappeared.
Juror number 13, juror 31, 3-1. Juror 7-5, juror 3-6, juror 9-8.
Juror number 33.
8.
Okay. Would any of you folks have any difficulty following the concepts that I've described? First, that the burden of proof rests entirely with the Commonwealth. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She's presumed to be innocent unless and until the jury determines that the Commonwealth has proved its case beyond a reasonable doubt. Is there anyone who would have difficulty following those very important constitutional concepts?
Juror number 58, 5-8. Juror number 8.
Okay. Now, I can tell you folks that after every jury trial, I talk to jurors, and they often tell me not only that their jury experience was an interesting one, but a rewarding one. I do understand, though, that for a few of you, however, service in this jury may be a substantial hardship, and let me explain what I mean by that. It's something more than mere inconvenience, because every civic duty we have causes us to be inconvenienced. It's far more extraordinary. It's something that would justify your being excused and a fellow juror having to serve in your place. I do understand, though, that it may be a substantial hardship. So if anyone has a substantial hardship, and what I typically mean by this is you have airline tickets or surgery scheduled during the course of this trial. But bearing in mind that this case may take 6 to 8 weeks to try according to the schedule that I've described, and keep in mind that I'll only excuse those who have a substantial hardship. If you think you are in that group, please raise your hand.
Juror number 97, 97. Juror number 47, 47. Juror 108, 108. Juror number 8. Juror number 50. Juror number 7. Juror number 23, 23. Juror number 24, 24. Juror number 90. Juror number 91. 106. 101. 34, 105, 70, 80, 60.
Juror 6, juror 109, 13, 31, 32, 88, 53, 140, juror 3, 102, 64, 82, 17, 17. Juror number 43, juror number 42, juror number 69, and juror number 63. Juror number 62, 62.
Juror number 41, 41.
All right. So in a few minutes, I'm going to leave the bench to give you a chance to fill out the supplemental questionnaires that we have. I ask that you not talk to anyone around you or share with any other prospective juror or anyone any questions or comments or concerns that you may have about jury duty, either generally or in this particular case. If you should have any questions or concerns, you can raise that when you come back to talk to me. So we appreciate your patience. We understand that this will take a while, but I will recess now for you to do that. All right, thank you.
All rise. We got a beautiful clock. Yeah, they don't have that fan. That's in the other courtroom. I don't like watching. No. 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 No, 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 no. What? You cut it off? No. Okay, we will keep an eye on them. Oh, clockwork wrong. Possibly was wrong. While we wait, would anybody like to watch the original opening statements? Just saying. You don't want to watch day one of the last trial? Really? Oh, really? You sure? Okay. Okay. I thought I had a good idea. I did. I thought I had a good idea. Hey, it's nowhere bad as Monica Simitily's. It was a day and 2/3. Monica Simitily was hell. A day and 2/3 opening statement on prosecution alone. Alone prosecution. Oh gosh, I'm so ready to go to sleep. I need a nap, y'all. I got 5 hours, if that, last week. Monica Simitily will be starting at 11:30 today, day number 36. Well, Gerald is saying yes. Yana, will I lose you if I play it for a little bit? Some people don't remember it. I need a pick me up. I need a pick me up, and it's way over there. Why don't I just play a little bit of it? Oh, but I don't want to lose you as a viewer, Yana. You're amazing, and I don't want to lose you as a viewer. But let's. He's got a long drive. That is so true. My honey boo has a very long drive home. He's been fabulous. I couldn't have survived Saturday without him and my son. I can't begin to tell you what a hell that was. That was hell. For those of you who don't know, I lost my service dog on Saturday. She passed away.
8.5, 2. Battery did kill and murder the said John O'Keefe and is guilty of murder in the second degree and not in the first degree in violation of General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield, County of Bristol, on or about January 29, 2022, at Canton in the County of Norfolk, did operate a motor vehicle upon a way as defined in Massachusetts General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in their blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicles that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described, did cause the death of another person, to wit, John O'Keefe.
That is where they were hung.
In violation of General Law, Chapter 265, Section 13.5. 003, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022, at Canton in the County of Norfolk, Did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24(2)(a)(2). To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you are to say so and no more. Jurors, hearken to the evidence.
Thank you very much. Will counsel identify yourselves, please, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Morning, Mr. Lally.
Morning, Your Honor. Laura McLaughlin for the Commonwealth.
Morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor, and ladies and gentlemen of the jury. My name is David Yannetti, and I represent Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, good morning, jurors. Before we begin, I have to ask you 3 questions that I'm going to ask you every single time we meet. The first question is, were you all able to follow my instructions and refrain from discussing this case with anyone? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we were last in court? No. Everyone said no or shook their heads. Thank you. All right, jurors, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you'll hear about during the course of the trial. But these comments are not intended to be a substitute for the more detailed instructions on the law, which I will give you at the conclusion of the case. This is the trial of a criminal case, as you've heard, and you've heard that the defendant is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death. I will describe in detail at the end of the case each of these indictments when I teach you the law, but briefly, murder is the unlawful killing of a human being. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. Again, these terms and elements of the crimes, including the additional crime of leaving the scene of an accident after causing personal injury or death, will be described for you in detail at the end of the case. Please remember that the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. So it's merely a formal manner of accusing a person of a crime to bring her to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or,
All right, well, zoom.
in this case again, and the duty of this court and this jury to adhere to the rule of law because it is so very important. Remember, John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. This jury will decide. This jury selected for this trial will hear and judge the evidence. You will decide what the facts are, and where the evidence is contested, you will determine where the truth lies. Ultimately, this jury, you folks, will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, you must ignore it so that in this courtroom, the rule of law will be upheld. This means that during the trial, until you retire to deliberate, you must not discuss this case with anyone. This includes family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any aspect of this case. You must not conduct any independent research about this case, the matters in this case, the individuals involved in this case. In other words, you must not consult the internet, including social media, and do anything else to find out any information from any source outside the confines of this courtroom. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We will go on a view, and I will discuss that with you before we go. Remember, you were instructed that you must not and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media or from any other source. It is critical that you follow that instruction, as hard as it's going to be. Finally, please continue to keep an open mouth. Now, I know that you will try this case according to the oath that you have taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice, bias, or sympathy for anyone, then you will arrive at a true and just verdict. And that's what we ask of you. So with that, it's time for opening statements. And whenever you're ready, Mr. Lally.
Thank you, Your Honor.
And I ask only that you keep your voice up, please.
Do my best. Good morning. So as Your Honor was telling you, this is one of the two opportunities that I will get to address. The first of which right now, essentially what I'm going to attempt to do, and I know you've heard over the course of the impoundment process a number of different witnesses that were listed out as far as potential witnesses in this case. So what my intent here is to provide as much of a roadmap as I can through those waters and help you to navigate sort of who these people are and what relation they have to this case. We start with John O'Keefe. John O'Keefe grew up in Braintree. He was 46 years old when he passed. He was the son of John O'Keefe Jr. and Margaret or Peggy O'Keefe. He was a brother to Paul O'Keefe and to his sister, Kristen Furbush. Kristen was married, and so John's brother-in-law was a man named Stephen Furbush, and they had two children who were very young in 2013. Now, in 2013, Kristen, unfortunately, tragically, passed away, succumbing to cancer in November of 2013. Within months of that, Mr. O'Keefe's brother-in-law and Kristen's husband, Stephen, passed away as well. Now, initially, when John O'Keefe's sister passed away, sort of the initial plan for that situation was that John O'Keefe was going to move in with Stephen Furbush and the kids and assist as far as raising them. And then when Stephen passed away a few months after his wife, before those plans could be final, John O'Keefe then moved in with his niece and nephew and assumed the parental role and assumed legal guardianship with respect to both of those children. Now, he was assisted in this by a great number of people within the town of Canton where the Furbushes lived and where John moved into the home with the two children there. There were other parents within the neighborhood, other parents within the children's age group. You'll hear from a number of them over the course of this trial, but they include Mrs. Carrie Roberts and Mrs. Jennifer McKay. They helped Mr. O'Keefe out during those initial stages and during the time that he assumed this role. He also got help from his work. John O'Keefe was a proud member of the Boston Police Department, had been for many years. He had been a patrolman prior to moving in with the children and assuming this sort of role. Boston Police Department helped him greatly as far as positioning him into more of a desk role, working in the sex offender unit with more regular hours to sort of assimilate himself to this new life and this new role that he assumes with these children. Initially, John O'Keefe lived in the house with the kids. However, in 2018, they moved into a new home, sort of a new home that they could have as their own. That home is located also within the town of Canton, sort of on the Stoughton side of Canton at One Meadows Avenue. John O'Keefe raised these children, assuming guardianship for them for about 8 years. His niece, who was the elder of the two, was about 14 at the time that John O'Keefe died. And his nephew was about 11 years old at the time that John O'Keefe died. January 28th, 2022. It was a relatively typical day. It was a Friday going into a Saturday of January 29th. Sort of typical in the sense of most sort of suburban parents. There were a lot of activities, weekend sports, practices, games, things of that nature that the O'Keefe and Furbush family had to look forward to. One little difference when it came to that particular day of January 28th and the 29th is the weather. So there had been predicted, and there was going to be a snowstorm, an insignificant one. A blizzard essentially was coming in overnight that Friday and the Saturday, lasting through most of the day on Saturday the 29th. And as a result of that, most of those sort of typical, weekend routine activities that would keep most people, including those within the town of Canton, busy, have been canceled ahead of time. Everybody knew what was coming. Everybody knew essentially you weren't going to leave your house all that much the following day. Now, also on January 28th, Mr. O'Keefe had received some news in respect to his niece. So his niece and her best friend were in 8th grade at the time, going to high school in the fall of 2022. They both applied to a private school called Bishop, and they both found out on the 28th that they had been accepted to that school. So the friend, as well as her father, a gentleman by the name of Michael Camerano, who's both he and his wife, Catherine Camerano, were friendly with John O'Keefe. They had children around the same ages as both John's niece and his nephew. And they had come over to their house on Meadows Ave that evening to celebrate the girls getting into that school. The nephew of John, the 11-year-old, was sleeping over a friend's house that night. He left that home sometime around 7 p.m. or so, got picked up and went to sleep over at his friend's house. John O'Keefe and Michael Camerano then decided to travel out to a local establishment on Washington Street called C.F. McCarthy's Bar and Restaurant. You're going to hear testimony and you're going to see surveillance video and you're going to see receipts and all kinds of things from a variety of different establishments, all sort of located within Camden Center along that strip in Washington Street. Now, they get Mr. O'Keefe and Mr. Camerano leave the girls at home. They then go to C.F. McCarthy's, arriving there sometime between 7:30 and 8 p.m. They eventually cajole another friend of theirs, Mr. Kurt Roberts, to come out to the bar and join them as well. And there's some other people that are located within the bar, including Mr. James Sullivan, who we hear from, who was present at the bar that night as well. Eventually, the defendant, Karen Reed, joins them at this establishment, C.F. McCarthy's, sometime just before 9 p.m. Now, John O'Keefe and Karen Reed had met sometime in 2004. They had dated briefly during that time and reconnected sometime around March of 2020, around the time of the COVID-19 sort of pandemic shutdown. They had started dating around that time period, or reconnected during that time period, and the defendant had stayed at the house in Canton several nights a week. She had helped out with the children. In the month or so leading up to Mr. O'Keefe's death, the relationship soured. You will see text messages between Mr. O'Keefe and Ms. Reed to that effect. You will hear testimony from the children, from John's niece and nephew, in regard to things they observed within that relationship. And you'll hear testimony from other individuals as far as their observations or things that they heard. Turning to January 29th, 2022. Just after 6 a.m., the Canton Police Department receives a 911 call from a woman reporting a mail party subsequently identified as John O'Keefe, found in the snow outside a residence at 34 Fairview Road. At the time, as I mentioned, blizzards that had been predicted was occurring, heavy snow, temperatures in the teens, wind bustling around. Officer Stephen Saraf and Officer Stephen Mulaney of the Canton Police were dispatched along with Canton Fire and EMS, and you'll hear from them in regard to their response and what they observed on scene. In particular, with Officer Saraf, he'll have as an exhibit that anticipates a cruiser camera video from his cruiser detailing or memorializing sort of his response in the darkness, in the blizzard type conditions as he's driving from the Canton Police Station, where he was located when he received the call, to 34 Fairview Road. When they arrived there, they observed three individuals, three females, sort of off to the left side of the property. When I say the left side of the property, I mean if you're standing out in the street facing 34 Fairview Road, off to the left side of the property, there's a flagpole, there's a fire hydrant, there's some bushes. That is where Mr. O'Keefe is located. To the right side of the property is sort of the driveway and the mailbox, other things that you'll become familiar with through photographic evidence and other means, of course, of this trial. The three females that the officers observed there were then identified as the defendant, Karen Reed, Mrs. Jennifer McCabe, who had received a phone call earlier in the morning from the defendant, as well as Mrs. Terry Roberts, who had also received a phone call early that morning from the defendant. The several firefighters from the Canton Fire Department you'll hear from in regard to their observations of injuries, abrasions, and lacerations to the right arm of Mr. O'Keefe. You'll hear their testimony in regard to swelling of his eyes and other injuries that he observed. They observed redness from the cold that he had been lying out in for some time. You'll hear the testimony from these firefighters, Timothy Nuttall, Anthony Flamati, Matthew Kelly, Francis Walsh, Katie McLaughlin, and Greg Woodville. And at least from three of those firefighters, you'll hear testimony anticipates detailing statements that the defendant made to them when they had asked about the origination of some of those injuries. The defendant stated repeatedly, I hit him, I hit him, I hit him. Mr. O'Keefe was then taken from the front lawn onto what they call a scoop stretcher. As he's doing that, I anticipate you'll hear Ms. Roberts' testimony that despite the 6 inches of snow approximately that was on top of Mr. O'Keefe's body and the snow throughout the roadway, front yard, everywhere around where he was, there was grass underneath Mr. O'Keefe, where his cell phone was located underneath his body as he lay on that front lawn. He was then transported by firefighters Kelly, Flamati, and Nuttall, as well as the ambulance being driven by firefighter McLaughlin to the Good Samaritan Medical Center. Once there are some observations, and you'll hear testimony from Dr. Justin Rice from that facility as far as observations consistent with what I anticipate you'll hear from those firefighters. But then there is a certain warming procedure that they go through trying to bring his body temperature up. Because when Mr. O'Keefe arrives at the Good Samaritan Medical Center, his body temperature is 80. And after those resuscitative efforts prove unsuccessful, Mr. O'Keefe is eventually pronounced by Dr. Rice at approximately 7:50. Shortly after that, when the defendant is then being driven away from the scene by Ms. Roberts, who is now going to go pick up Mr. and Mrs. O'Keefe, Jonathan's parents in Braintree, and then bring them to the Samaritan Medical Center in Brockton, the defendant makes some statements of self-harm. As a result of that, she's then transported to the Good Samaritan Medical Center as well by two firefighters named Daniel Whitley and Jason Becker. And amongst the statements that they gained from the defendant as they're having a conversation with her in regard to that, in regard to her treatment and diagnosis, she indicates that the last that she saw Mr. O'Keefe, they had gotten into an argument before he had gotten out of the car in front of Fairview Road. Now, you'll also hear testimony from some of the other first responding officers from the Canton Police Department, including Lieutenant Paul Gallagher, Sergeant Sean Good, and Sergeant Michael Lenk, in regard to their initial response, their observations, people that they spoke to, where they went, and their ability to recover within these blizzard conditions that are still ongoing, certain pieces of evidence that they located in around the area where Mr. O'Keefe's body was found. You'll also hear from Lieutenant Charles Ray, Canton Police Department, who was tasked with, at this point in time, the Canton Police weren't aware that the nephew was over at a sleepover. They weren't aware that Mr. Camerano had come over to the residence on Meadows Ave and picked up the niece, bringing her back to his house as she was left unattended when the defendant left to go looking for Mr. O'Keefe. So unaware of that, they go do a well-being check at approximately 8:22 in the morning. And they also have cruiser camera video attached to their cruiser. You'll see that video and when they pull into the driveway at Meadows Ave, approximately 8:22 in the morning, they pull in directly behind where eventually you'll hear Ms. McCabe left the defendant's vehicle after driving it from her house to Meadows Ave in search of Mr. O'Keefe. And you'll have that footage, and you'll be able to see the back of the defendant's vehicle, specifically the right rear taillight of that vehicle. Now, you'll also hear testimony, as I mentioned, from the Cameranos, from Mr. Roberts, from Mr. Sullivan. Also, they were all present with the defendant and Mr. O'Keefe at C.F. McCarthy's. You'll hear testimony from a number of other individuals who were at the Waterfall. The Waterfall is a bar located across the street, essentially, from C.F. McCarthy's on Washington Street in Canton Center, and somewhere that Mr. O'Keefe and the defendant went after leaving C.F. McCarthy's at approximately 11 p.m. Now, from that establishment, you'll hear from Rebecca Trayers, who was working as a bartender at the Waterfall that evening. You'll hear from a couple named Nicholas and Karina Polakaitis, who were friends of friends, who had known Mr. O'Keefe through their daughter around the same age as Mr. O'Keefe. Mrs. Polakaitis had some conversation with the defendant that evening, as well as herself and Mrs. McCabe at the Waterfall. She left around the same time as they did. She parked on Washington Street around the same area as Mr. O'Keefe and Ms. Reed did, specifically in Ms. Reed's car. And she observed Mr. O'Keefe and the defendant walking toward the defendant's vehicle, and specifically the defendant walking towards the driver's side. Now, you'll hear testimony from a Christopher and Julie Albert, who were people who were at one point neighbors of Mr. O'Keefe. They knew him well from being neighbors of him. Christopher Albert owns a pizza shop, also located within that Canton Center area. Mr. O'Keefe, earlier in the day of the 28th, had been into that pizza shop along with his nephew to get his nephew a slice. Christopher Albert and Mr. O'Keefe had some conversation regarding what they were doing that night, and it's Christopher Albert who actually texts Mr. O'Keefe and indicates that they're over at the Waterfall and that he should come over shortly before Mr. O'Keefe and the defendant make their way from C.F. McCarthy's home. Now, Christopher Albert left directly from the Waterfall and went home. He was sort of walking distance away from him. His wife, Julie Albert, had left earlier in the evening. There was a band playing at the Waterfall that night. Julie Albert started to get a migraine, and she left before most of the group. Included within that group, and sort of how they came to the Waterfall, the Albert family in particular, Julie Albert went there along with her sister-in-law, Nicole Albert, as well as her niece, Caitlin Albert, her niece's boyfriend, and Mr. Tristan Morris, and they had had dinner at the Waterfall earlier in that evening. Now, Nicole Albert lives at 34 Fairview Road. She has a husband named Brian Albert, who's also a Boston police officer. Brian Albert had gone with a friend of his, who's also in law enforcement, a man named Brian Higgins, and they had gone separately, but had come home together from a funeral for a fallen police officer in New York City. Came home early to sort of beat the weather, and eventually they meet up with Brian Albert's family at the Waterfall. Now, Tristan Morris, who was Caitlin Albert's boyfriend, had left the Waterfall at some point in the evening. He then returns later to the residence on Fairview Road and picks up Caitlin Albert, brings her home. All of this is in relation to Brian Albert and Nicole Albert's son, Brian Albert Jr., whose birthday was coming up the following day, the day of the snowstorm on the 29th. So he had been back at the house at 34 Fairview while his family was out at the Waterfall. He had a number of friends that had come over that evening to celebrate his birthday with him. Now, among those friends was two individuals named Sarah Levinson and Julie Nagel, and they were at the residence at 34 Fairview for a good portion. Now, those individuals from the Waterfall that leave and then come to 34 Fairview, they do so sometime shortly after midnight. Shortly after midnight is when it starts to snow. Flurries are starting to come down. Snow is starting to stick to some degree to roads, to front lawns, grassy areas around town. Now, from that group, the group that goes back is obviously Brian Albert and Nicole Albert as they live there. Caitlin Albert, because it's her parents and her boyfriend is picking her up, as well as Jennifer McCabe, who is Nicole Albert's sister, and her husband, Matthew. They go back to that, and there's an open invitation to essentially anybody that's there. John O'Keefe takes them up. There's certain text messages and phone conversations between John O'Keefe and Jennifer McCabe as to where this house is located, as he's never been there before. And then he and the defendant drive in the defendant's vehicle to 34 Fairview. And once there are several witnesses from within the home that observe the vehicle parked in. So I mentioned earlier there are two females that were with Brian Albert Jr. at the house, one of them being Julie Nagel. some point, she had called her brother, Mr. Ryan, for a ride home. He then gets a ride from his friends, Ricky and Antonio, as well as Mr. Nagel's girlfriend, Heather Max, was riding in the back of Mr. Antonio's pickup truck. I say that because they arrive at Fairview Road around the same time as the defendant. The defendant is coming in from one direction, the pickup truck with the Nagel brother is coming in from another direction. The pickup truck that the Nagel brothers riding in flashes its light, signaling the defendant to go. She goes first, they follow in behind, and lo and behold, they end up at the same house. They park the pickup truck somewhere in that right side of the property, facing it from the street in the area of the driveway, and the defendant in her black Lexus SUV parks a little bit further up. Different people from within the pickup and different people from within the house observe that Lexus SUV in one location, pull up a little bit further, and then pull up a little bit further until it's in the area of that fire hydrant, of that flagpole, where Mr. O'Keefe is located the following morning. Now, from their position, so I anticipate the testimony that you're going to hear is that Heather Maxon from that pickup truck observes a male passenger and a female operator when the pickup truck operator flashes those lights at the vehicle as they're facing each other before they pull down. What you'll hear also, I anticipate, from all three of those individuals in the pickup and Julie Nagel, who comes out to the pickup to talk to the brother, is that no one ever exits that vehicle. There are no footprints around that vehicle. There's no damage that they observed to that vehicle at that time. Again, it's just started to snow. Things aren't sticking really too much at this point. Julie Nagel has a conversation with her brother, decides that she's going to stay at the house longer, so the arrangements for a ride home, and the pickup truck leaves from that point. As they pass by, they observe a female operator matching what I submit as the description of the defendant. From all of those people within that house that evening, none of them at any point in time observed John O'Keefe come into the house. They see the vehicle out front, they see the vehicle pull away, and they just assume that they left and that no one was coming. Clear testimony from other individuals.
Need to let you know that the fan is back on, so there may be some movement in the near future. Don't go away. We are rewatching the original opening statements. It'd be nice to compare for the new ones. Just FYI.
Who were at the house that night, including Colin Albert, who is Julie and Christopher Albert's son. He's also the cousin of Brian Albert Jr., who is having people over for his birthday. He's leaving the house around the time that the initial people coming back from the waterfall, which includes the homeowners, and Mr. Higgins, are sort of coming into the house. At that point, Colin Albert was leaving. He's getting picked up by a young lady named Allison McCabe, who is Jennifer and Matthew McCabe's daughter, who's also friends with Colin Albert and also cousins of Brian Albert Jr., who's within the home celebrating his birthday. As I mentioned, you'll hear testimony from Matthew McCabe and from Jennifer McCabe in regard to their observations that particular evening, both at the waterfall as well as at the residence on Fairview Road. And then you'll hear testimony in regard to a phone call. A phone call that Jennifer McCabe receives from John O'Keefe's niece at approximately 4:53 in the morning. She answers that phone call, speaks to the niece briefly, and the niece hands the phone over to the defendant. Now, you'll hear testimony from the niece as well, that about 4:30 in the morning or so, the defendant came into her room in a frantic state, saying that Mr. O'Keefe had not come home the night before. So initially, when the defendant is talking to Ms. McCabe, she indicates to Ms. McCabe that the last time she saw Mr. O'Keefe was at the waterfall. Eventually, as Ms. McCabe is waking up, she reminds the defendant that she not only saw them leave the waterfall around the same time as herself, but also saw the vehicle, the defendant's vehicle, outside of the home on Fairview Road. Eventually, the defendant, while driving around, this will come in as far as other testimony and related testimony as it develops. But she's driving around in that morning. She's calling a bunch of number of different people, friends of Mr. O'Keefe. She's calling Mr. O'Keefe himself. She also calls Ms. Roberts. So Terry Roberts receives a call about 5 a.m. from the defendant indicating that Mr. O'Keefe did not come home, indicating that he got hit by a plow or that he must be dead. Ms. Roberts then gets ready. Mr. McCabe is getting ready as they're all sort of planning to go out and look for Mr. O'Keefe and see if they can locate him. They call numerous times. You can see that within the text messages and the phone extractions from a variety of people's different phones throughout the course of this trial as well. So eventually the defendant comes to Ms. McCabe's home, indicates at some points prior to that she has a cracked tailpipe. Ms. McCabe then gets in the driver's seat due to the defendant's frantic state. Ms. Roberts is there as well. Ms. Roberts follows Ms. McCabe driving the defendant's vehicle back to Mr. O'Keefe's residence on Meadows Ave, checks on the niece. The defendant then shows both Ms. Roberts and Ms. McCabe the damage to her right rear taillight, which is essentially missing a number of different pieces from that right rear taillight. They then proceed off to drive and see if they can locate Mr. O'Keefe. The defendant is insistent that they go to that residence on Fairview Road. Again, they're driving down there in the dark, in the snow, in the wind, in the blizzard. As they approach towards that residence, there is one person, so they're seated within the vehicle. This is Ms. Roberts' vehicle. She's driving. Mrs. McCabe is in the front passenger seat. The defendant is in the rear passenger seat. The defendant is the only one who sees Mr. O'Keefe. He yells and screams at Ms. Roberts to stop. Ms. Roberts and Ms. McCabe, I anticipate, will testify that they did not see Mr. O'Keefe, not only as they were driving past him, but even after they got out of the vehicle until the defendant gets out of the back seat and makes a beeline essentially right over to where Mr. O'Keefe's body is found. Mrs. McCabe then dials 911, and shortly after that is when the officers and McCabe firefighters arrive on scene. Now, while they're waiting there, at approximately 6:23, 6:24 a.m., during a conversation with the defendant asks Mrs. McCabe to look up on her phone how long someone has to be out in the cold to die from hypothermia, or something to that effect. And you'll hear some dispute as to when that search was made. And you'll hear testimony from 3 different forensic extraction experts, Mr. Nicholas Carino, Ms. Jessica Hyde, and Mr. Ian Whiffen. You'll hear about a lot of these things called extraction reports from cell phones. And the extraction reports are done with a program called Celebrate. Mr. Whiffen is someone who writes that software for Celebrate. Dave's phone was done at the same time frame that she indicates the defendant requested her to do it, and that at 6:23 and 6:24 morning. You'll hear testimony from Ms. Roberts, Ms. McCabe, the firefighters, and the responding Kent police officers about a repeated phraseology that the defendant stated while there, asking again and again in regards to Mr. O'Keefe, is he dead? Is he dead? You will also hear testimony, as I indicated, about sort of treatment that she received at the Good Samaritan Medical Center, and that would involve testimony from Ms. Daisy Hormseth, Ms. Kathleen Wilford, and Dr. Gary Fowler. You'll hear testimony from a number of different analysts from the State Police Crime Lab and from some other laboratories as well. Included within that will be Mr. Nicholas Roberts and Ms. Maureen Hartnett, Mr. Andre Porto, Ms. Ashley Vallier, and Ms. Christina Hammond, those all being from the State Police Lab. You will hear testimony in regard to an incident which occurred earlier in January, right around New Year's. Mr. O'Keefe, defendant, and the children have been invited with a much larger group, approximately 70 people or so, to spend New Year's in Aruba. This is a trip that was organized by a friend of Mr. O'Keefe's named Laura Sullivan. We'll hear testimony from her, as well as from her sister, Miss Marietta Sullivan, as well as you'll hear testimony from the 2 children in relation to this. And essentially, day 2 or so of this trip, Marietta Sullivan, the sister of Laura, is walking through the lobby and she runs into Mr. O'Keefe. This is someone she refers to as godfather, because John O'Keefe is also the godfather of Laura Sullivan's son. Runs into him in the lobby, gives him a hug, and sort of pointing him in the direction of where she believes he's going into his room. The defendant is in the area. The defendant starts yelling and screaming and swearing at Ms. Sullivan. Ms. Sullivan responds in kind. Essentially, for the most part, the Sullivan sisters see very little of Mr. O'Keefe throughout the remainder of their trip to Aruba. And we also hear testimony from the children that shortly after this, or immediately after this, there is a approximately 20-minute screaming match going on between Mr. O'Keefe and the defendant within their hotel room in front of the children. Now, you'll also hear testimony from the defendant's phone in regard to, and from another individual's phone in regard to that arrangement, in regard to text messages of an amorous nature that she had with Mr. Brian Higgins, who was at the waterfall, and also at the residence on 34 Fairview, because he was friends with the homeowner, Colin Albert, but he was also friends with Mr. O'Keefe and had also met the defendant. And throughout the course of those amorous text messages, there's references that the defendant makes to that incident in Aruba, as she purports.
Yeah, they took the camera off the clock and put it on the fan.
To be Mr. O'Keefe cheating on her. She insists that he was making out with Marietta Sullivan in that lobby as opposed to her giving him a hug. It makes repeated reference to that within the contents of those text messages as well. Now, you'll hear testimony from a number of different other individuals. Mr. Michael Trotter, who has a supervisory role at the Canton Department of Public Works. You'll hear from Mr. Louis Jutras, who has a supervisory role with regard to IT, in regard to certain video that was recovered from the town of Canton, as well as from a temple located along the route that the defendant traveled, both away from Fairview that evening, as well as to Fairview from the waterfall, away from Fairview to Mr. O'Keefe's residence on Meadows, and then later in the morning at 5. Because if you recall, Ms. McCabe, I anticipate, will testify that she receives the call from the defendant about 4:53 in the morning. The defendant then drives around Canton for some perceptible half-hour or so period of time prior to even getting to Ms. McCabe's. And what I submit the evidence, or what I anticipate the evidence will show, based on sort of the tracking of her phone records, testimony you'll hear from Lieutenant Brian Tully of the state police, from these faulty records and RTT accounts, that the defendant, while she's using her phone, is driving in the direction of Fairview Road prior to going to Mrs. McCabe's house, where she meets Mrs. McCabe and Ms. Roberts. Now, again, you'll hear testimony from a number of different troopers who were involved in the investigation. With regard to this case, you'll hear from Trooper Michael Proctor and Sergeant Jerry Mechanic of the State Police. You'll hear from Lieutenant Brian Tully. You'll hear some testimony from Trooper Joseph Hall, who's in a specialized unit within the State Police called PAWS for short, but essentially a collision analysis and reconstruction section within the Massachusetts State Police. His examination of the vehicle, his examination of the scene, his examination of specifically some Toyota texture, because Lexus is essentially owned by Toyota or vice versa. So there is some data that he's able to recover from that and back the vehicle up based on its known locations and travel. He cycles, essentially opines, anticipate he'll opine that around 12:45 in the morning, when the vehicle was in front of the residence on Fairview, that for some perceptible period of time, that vehicle travels over 60 feet in reverse at over approximately 24.2 miles per hour. Now, you'll hear testimony, as I said, from a number of different troopers, as well as from a number of different analysts from different labs. Included within that is Ms. Maureen Hartnett, who collected items from the vehicle, the defendant's vehicle, including the taillights, sort of housing from that vehicle, pieces of the taillight that were discovered in sort of front grass, front street area. There is a specialized team called the CERT team. You'll hear from Lieutenant Kevin O'Hara, who has a supervisory role in relation to that. And then later on that day of the 29th, he, along with Lieutenant Tully and a number of different members from his CERT team, were searching for evidence within the mounds of snow in front of that house, as the blizzard is still ongoing at this point through sort of the afternoon hours. Among the items that they locate is a sneaker. When Mr. O'Keefe is transported to the hospital, he's found to only have one sneaker on his feet. They find the other sneaker in that area of the body. They find various pieces of taillight. And as is wont to do, over the course of the following days, the temperatures rise, rainstorm that comes in, and the snow melts. Over those successive days, there are additional pieces of taillights that are eventually discovered in that area of the front lawn on the street. Now, from these different pieces, Ms. Hartnett also locates a cocktail glass that's located on the bumper or the rear area of that scene, and she locates a human hair on the back of that defendant's vehicle as well. Now, the cocktail glass on the bumper, you'll also see surveillance video from the waterfall, and Mr. O'Keefe is observed on that surveillance video essentially walking out of the waterfall with a cocktail glass in his right hand. Same right hand that has minor injuries to it, and the same right hand that's attached to his right arm that has the abrasions and lacerations that are observed by the paramedics, that are observed by the doctors at Good Samaritan, and are observed by the medical examiner as well. We'll hear testimony from another analyst, Christina Hanley, about the forensic consistency between a drinking glass that was in the defendant's bumper and the drinking glass pieces that were found on scene 34 Fairview. You'll hear her testimony in regard to pieces of red and clear plastic that were microscopic in size that were found within Mr. O'Keefe's clothing. Consistent, in her opinion, I anticipate she'll testify, with the same pieces of plastic contained within the defendant's taillight. You'll hear from an Ashley Valley, who works for the lab as well, and how she fit the various pieces of broken taillight from the scene together and over that taillight housing, finding them to be consistent with each other as well. You'll hear testimony from Andre Porto, who does essentially DNA analyst for the lab, and samples that were DNA samples that were taken from the taillight, from the clothes of Mr. O'Keefe, and the broken drinking glass that were consistent with Mr. O'Keefe. Those items were also sent, the taillight pieces, taillight DNA was also sent to the independent lab, Voting Technologies, located in Northern Virginia.
Sergeant Kowalski, please.
You can sit down, sir. Thank you.
Thank you, sir.
So we're at the top.
I don't know what's happening, y'all.
Ms. Gilman, can you please resume the interview? Thank you.
We'll do the right thing right now. We'll do better.
And
Okay. Just go to voice.
All right, you're a very successful man. You told me the chief, you're all this. Yeah, but you know what? You're a good person. You've had a successful career. Came to this country, done very, very well. I saw you guys. You've done very, very well. And this doesn't make you a bad person. No. What happened with you and Katie?
I don't know what's going on. We'll figure it out.
Things might have got out of control the other night. But like I said, you can't be defined for one night. So we're trying to help you out there. How do you keep this out of the story? Do the right thing then. Just want to know where she is looking right now. Okay. Yeah. All right, we know you can't put that woman on what? Hey, what's that?
I'm Detective Deborah Gotsky. I work.
bad person. You know, what happened with you and Katie? Things might have got out of control for the night. But like I said, you can't be defined for one night. So we're trying to help you out there. We're trying to keep this out of the story, you know. Do the right thing, man. You just want to know where she is right now. Okay. Yeah. All right, we know you can't go that no matter what. Hey. What's that? Sorry, bud. I'm sorry, you guys say something.
No, we know you care about her a lot and you love her. And we really need you to do the right thing. We can't have her out there another night, Harry.
I'm sorry, I didn't hear you.
Harry, it's the right thing to do. We need you to tell us where she is so we can bring her home to her family.
Yeah. I don't know. In the same courtroom as the Karen Reed hearing. I don't know.
Gary, we're all counting on her right now. We gotta talk to her sister tonight. We gotta talk to the kids tonight. We can't let them, we can't give them no answer. It's, I don't wanna be so blunt, but I mean, we can't go back to them and say we don't know. We can't do that. It's just,
Did you ever hike in the woods near your house? Did you ever go for walks on the trails? Not near the house. In Dover, have you? What trails do you usually go?
I'm not sure what the name is. That's where the tennis courts are.
The tennis courts?
Yeah, in Dover, the tennis courts. And there's a trail. Actually, we did that with Katie together one day, but not recently. Yeah, that's the trails that we typically use.
Do you usually go the same route?
Yeah.
Yeah? Do you know what street it's on?
I think it's Dedham Street, but I'm not sure. Again, there's just one area where tennis courts are, and there's a trail starting in the back corner.
What was your favorite part about those trails?
favorite part is that it goes all the way up to some small little mountain where you can see Boston.
Oh, really?
Yeah.
Does it have a name?
I'm not sure, I don't remember the particular name. Lower Park, but again, it's wonderful. I'm not 100% sure.
Is that the only one you guys would hike at?
As far as I remember, yeah.
How often would you guys go?
Again, it must have been last year in the summer or so. Recently, Katie and I drove to Lincoln to walk in Lincoln, which was new for me. But not in Dover.
Did you go to this trail in Dover often?
Yeah,
How often would you say?
once a week.
Once a week at least?
Is that a walkable trail or? Yeah, it's a pretty wide trail.
And that goes up to the, you said Boston?
I think there's several trails, different colors. And one of them, I'm not sure which one, was deep under the top of the mountain.
When's the last time you guys were there together?
I don't really remember exactly, what must have been a while. Months, many months.
Was that a special place for you guys?
In a certain way, yeah.
Yeah, have some meetings you guys as a couple to go there?
We always enjoy, hiking together. Yeah.
Yeah.
Alright, you're up there the other night.
Did you bring her up there the other night?
I don't think so, but I'm not sure. I'm not sure.
Did you bring her up to the mountain the other night, Harry? Did you bring her up to the mountain the other night, Harry?
I don't remember anything.
Come on, Harry, get off your chest. Yes, get off your chest. You're gonna feel better. You're gonna feel relieved. You're gonna know you did the right thing. Alright, you're up to that night.
He was angry. He was angry for whatever reason, I'm not sure why. Yeah. Although the day was nice. In the evening,
sure. No, you're up there. Yes. There's no way up there. You don't want to, it's gonna get dark. We want to get this done.
Thank you, Yana.
All right, drove the Jeep up there, I think.
We're up there, can we find her, Harry?
I'm telling you about it. I don't know. Like where she is, about that. All I know is we were sitting downstairs watching TV, and under that, as I said, she was arguing, she was angry, very aggressively talking to me about her being angry about stuff, and I was drinking whiskey. And so she was drinking something too, but I'm not sure.
Remember what the argument was about, why she was mad?
What's that?
Remember why she was mad?
So it was, rotating about the same thing that I tried to divorce her in January. She came always back with that, oh no, although she also suggested that we should just let it go and fix our marriage. And she came back to that thing always, well not always, repeatedly, that she was very angry that I made a decision that I'm able to go to Germany to continue my career.
Harry, tell us about the text you sent to Colin.
That's what?
Text you sent to Colin? Kyle? Remember?
I think it's Kyle.
I don't know what text you mean. I don't remember what I said in the text.
You know Kyle,
What?
right?
I don't.
Kyle,
No.
from town?
What?
From Dover, from town?
I don't. No. Doesn't anything, Kyle. I don't know, Kyle.
Kurt,
That's it.
I'm not sure about it.
do you remember sending Kurt a text message?
No.
No?
No. Then.
At 4:31 a.m. on Friday.
She's angry. She's angry for a lot of reasons. Although she wanted to fix it, I don't understand.
We are still waiting for, I guess, the Karen Reed information, but for now, we're just going to hang.
You sent Kurt a text message at 4:31 a.m. on Friday
Hey, Miss Di,
stating, Kurt, I am sorry, brother, but she is a vindictive devil. She played us all. I am really sorry, brother, but she manipulated us all. Love you. Do you recall that message?
No, I'm serious. I have no recollection having sent any kind of that message. No. No, I haven't sent any message.
And you sent that
I
message.
got to go to new hearing aid battery. I'll be back.
Yeah.
I really have no idea.
Not too long after you sent the message, you're back at the hotel. Oh, yeah, this isn't going away. The only way we get headed in the right direction is just behind us, is just please talk about it.
And I said, she was angry, and that's the last I went in. I'm not sure if she walked away or just sitting there.
Saying that she would leave the home and tell her papa wasn't home.
She wouldn't leave her kids.
We want our kids to have, we can't do this with the kids. They're gonna do well with that, they have.
What do you think happened? I don't understand.
Did you tell us what happened? Did you tell us which was? I want to find her quickly. You were on top of that mountain that night.
That's right.
You were up on that mountain that night.
We know you were up there for a couple hours. You were up on that mountain for a couple hours that night. You were up there for a while. Where can we find her up there?
I don't even know when I was out there for a couple hours. It's a good woman. I don't know. This story. Updates today?
Today's Saturday evening now. Let's go back to the argument that night, watching TV. So you need to go back to the argument, watching TV, and take us through what happened.
Again, I'm not sure we call it in words, but I believe that went on the same topic that she had a hard time getting over the fact that in January, I was talking to a lawyer looking into divorcing her. And then she believed I would throw her out, which was not what the plan was. Or the idea, there was no real plan actually. It was just playing this out, this potential projection in terms of what I was supposed to do or we supposed to do. So I think that was the argument in terms of still being angry that I tried to pull myself. Yeah. But I'll ask her. Why wouldn't you come to me? Back then, December, January.
What happened next?
There's a history and it's changing. Maybe there's more arguments, I don't know.
She hit you, Harry? At night?
I don't think she did. So that's what I remember. She was angry, really angry, and I didn't understand. And all kinds of words. I mean, that was.
What'd she tell you? What'd she say to you?
Not sure. Motherfucker or something like that. Fuck you off, fuck you. And I said, oh, that was good.
She become violent?
Not sure. Something like that.
So how do you have dinner? Was that from just a slap or was that pushing to a punch?
Something.
Was it her hand or her object?
Maybe it was a glass or something.
So you have to defend yourself. I think you have a glass. Glass all over the bedroom. Glass.
Mm-hmm. Maybe I did defend myself, I don't know.
Naturally, anybody wouldn't get her a glass. I said there's glass everywhere. You remember how you had to defend yourself? What happened? Sounds like you had no choice but to defend yourself.
My always have a choice, no?
What's that?
You always have a choice.
Yeah, but
She's a beautiful woman, but she had her volatility in scenarios always kind of down. I was ready for a fight. Struggling, to be honest.
yeah.
Hey guys. Oh, my ears, sorry. Trying to put a necklace on. I had to get new batteries for my hearing aids. So
April 9th, he's discharged. Okay.
they are on a court break, obviously. Was this done? Yes. Okay. So Karen Reed is on a court break. Yay. No. We're just going to stay here and we're going to hop on over to the other trial that we were watching earlier. This is going to be the Linda Sturmer trial. And then what we're going to do is I'm going to keep an eye out for Karen Reed and put her back up when she comes in.
Yes.
On the trial, unaliving her husband by burning him and running him over with a car.
You'll have me for a little while.
Morning, Mr. Shinsky.
Good morning.
So I believe we left off last week. You were conducting an interview in the driveway with the defendant. Is that correct?
Yes.
And that was at the scene.
Yes.
And so is this common to do the interviews at the scene?
Yes. Normally we would drive up, meet with homeowners and work right out of our vehicle and conduct interviews, everything right on that site.
And when you typically conduct these interviews, is it common for people to interrupt or come up to the car or come up to the scene?
Yeah, not unusual. Neighbors, people passing by, family members, will come up. Oh. Okay. And to have people walk up, curious people, things like that is not unusual at all.
So granted, this is just a few days after the fire that you're conducting this interview, correct?
Correct.
So you're saying that it's common for people to just be curious as to what happened and stop by?
Yes.
And you conducted an interview, I believe, on January 9th and one on January 10th. Is that correct?
Yes.
And I believe, I'm not sure where we left off, you had recorded those interviews?
Yes.
And then they were transcribed into an actual written transcript. Is that correct?
Yes.
And were you able to then check the accuracy of the recording against the transcript?
Yes. Our clerical staff would type it and then you listen to the transcript, read it all the way through any corrections or anything that need to be done are done so that it accurately matches what the recording has on it.
And you did that and you checked it for correct accuracy?
Yes.
I'm going to show you what's been marked as people's proposed exhibit number 6. And if you could just flip through this for me and tell me if you recognize that.
Is that Karen Reed?
It appears to be the same.
And it's the same. Are there any corrections, deletions, or changes to it from when you originally provided the transcript?
Yes, there has been areas that have been blacked out.
And does it appear from just glancing through that many of those areas that are blacked out are some of those extra conversations?
Yes.
Conversations with those in the car as well as those approaching the car?
Yes.
Your Honor, at this time I would move for people's exhibit number 6 to be admitted into evidence. I'm going to have you maintain that as we go through some of them and show them on the screen. As part of your interview with the defendant, did you have a drawing or like a floor plan done of the house?
Yes, it was done, I believe, by the end of the first interview, that first day. Ms. Dermer had appointments and had to leave. And then her daughter, Brittany, came to the site, and she's the one that actually provided a floor plan of the upper and lower floors.
And when you say the upper and lower, would that be the main level and the basement?
Yes.
And did the defendant have an opportunity to look at that floor plan?
Yeah, on the second day when I did my interview, a lot of that second interview was going through the floor plan, just with a general description of the building, what was in it, contents, items. Significant amount of the interview was pertaining to the layout and what was in the building.
And did she adopt that drawing that was done by her daughter as accurate?
Yeah, I believe she did.
Boy, that sucks as a judge. You see that light shining in on her face and she's all hiding it? Poor judge.
Who is that woman?
Your Honor, at this time, I believe defense counsel is stipulating to the admission of people's exhibit number 7, which is the floor plan and is 2 pages.
Yes, Your Honor.
People's exhibit 7.
Thank you, Your Honor. And then permission to publish the jury. And again, this floor plan then was used throughout your conversations in the interviews conducted to use it as points of reference.
Yes.
Oh, and Your Honor, there's a copy for each juror. So I've stapled the first and second page together and made a copy for each juror. And I'm sorry, and this was something that you referred to then throughout the interview in terms of getting points of reference. Is that correct?
Yes.
Okay. So I'm going to have counsel then load up the transcript, and I'd like you to have it in front of you so that we can go through it together. I'm not going to have you read all of it, so I'll direct you then to what pages, since it is so lengthy. So I'm just going to have okay, this is the first page of the transcript, and this is just where you introduce yourself, and does it list out then the people that are attending?
Correct.
So I'm going to have you go to page 4 of the transcript. Page 4 for me. At the top of the page, there's a J and there's an L. What does the J stand for?
The J is me, and the L would be Linda Sturmer.
So the J is for your first name, Jim?
Yes.
Okay. And so I'm going to have you start at the top of that page and read then through that large paragraph. So start with the question that you asked at the top of the page and then read through her statement to you. And then just be mindful then of the redactions.
Yes.
Thank you.
The question is, okay, go ahead. If you want to just with Sunday morning or what was going on. Answer, Sunday morning, I had got up and went down to the marathon and gotten some eggs and some breakfast meat and stuff to cook that morning. Filled up the blazer and then came home, started coffee, and Todd was still in bed at that point. He got up and I.
Okay, guys, sorry. I sat there and tried 7 batteries, and they're all dead. And then Gerald called, so I had to take. We're dealing with stuff with my dog. I got her cremated. So anyway, yeah, interesting day, y'all. Which live of Karen Reed trial? Oh, okay. That's good there. Okay, I'm gonna keep looking for Karen Reed stuff. Hi, Dave. Hi, Yana. Hi, Ronnie. Everybody. Adair. Oh my gosh. Adair. Hello. Hi, Taylor. Welcome, everybody. Welcome, Miss Diane. All right, back to court.
I gave him the receipts for his medicines, prescriptions, and the last couple of days' receipts that I had spent. He got very angry with me because I hadn't recorded them in his checkbook and told him about them sooner. And he was screaming at me about that I went downstairs and woke the boys up. I think it was probably 10 maybe. And the boys that they could go to the mall, and I gave them some money for lunch or breakfast if they wanted. And that Dad and I needed to talk about some things. I went back upstairs. I didn't remember if I started a load of laundry then or if it was a little bit later. But I went back upstairs. I made Todd some breakfast and told him I was going to send the boys to the mall, and then we could talk about everything. I was going to be going to my sister's to stay for a little bit, and so I made him breakfast, and he took his medicines. We really didn't discuss all that much more. And he sat down, watched some hunting program in the living room. I did some laundry and some dishes, and came back upstairs and had to read the instruction booklet for my son is on special prescription that you have to enroll on the computer and answer questions, and that I guess monthly. So we were gonna get back his blood work, or going to get his blood work done on Monday. So wanted to get it all in the computer, end of it done on Sunday. I must have fallen asleep. I was laying on our bed reading the book. I took a little nap. And when I got up, Todd had asked me something to drink. I went to the kitchen and was loading the dishwasher and washing up his breakfast dishes, and I got some juice, and he took some medication, and I told him I was going downstairs to do some laundry, deleted section. So I restarted the laundry because I still needed, I restarted the laundry then because it smelled. So I restarted it, and then Todd was yelling at me, and then all of a sudden I heard him scream. Then I went running up the stairs, and there was fire from our bedroom to his recliner, and he was on fire. And the whole upper body, and his whole upper body, there was fire and smoke. I couldn't see him really well, and I just turned and ran out the door and jumped in the van because I didn't know how I would get anybody, except I would go over to Mike and Connie's, and I backed up, and then I seen Todd in the yard, and I got out to try to help him get the fire off of him. Before that, I heard something in the house, boom.
I'm going to have you go ahead and read the last two sentences on that page and then continue on to page 2.
Yeah. Now, in the morning, you ran and got breakfast stuff. About what time? Do you remember? Do you recall what time it was? Around 9 or so.
And if you could go to page 5 and read down then to where there is a J and it says O before the blacked out boxes. Yep, page 5, just start at the top.
You can start at the top of 5.
Start at the top of 5 and read down to the blacked out area.
This is the trial we were watching yesterday. This is day 2. Okay. This is day 2, day 3. And Simatilli trial should be starting in a few minutes. I'm going to hop over there. I'll teleport you. Then what I'm going to do is if Karen Reed comes back, we'll teleport back over to, I'd say teleport, redirect, back over to Karen Reed. It is a crazy day. They should be getting into the jury selection, and they may be in the part that we can't see. It is, and I'm sorry. I don't know what else to do. I mean, the only thing I can do now is for us to end this live in about 5 minutes, 10 minutes, and go over and us finish the Monica Simatilli trial. We actually have 4 trials that we are part of going all at the same time. All at the same time. This is on the bottom of my importance. It's Karen Reed, Lori Dayville, then Monica, then this trial. All 4 happening same time. Monica Simatilli is in day 36. Should have been done a long time ago. Diane, you're muted.
I said, I got so many computers going. I need you to send me a picture of your thing that holds your computers, your 2 computers. Okay?
You mean my monitors or
Yeah.
the computer?
Well,
monitors.
Yeah. The name.
Not the computer.
No, not the computers, your monitors.
All right. I'll send it to you in a minute.
All right. Love you. I got
Bye.
you.
Bye. Okay. So, well, they just kind of did this. And the thing is when they do this, I mean, Monica Simatilli was only slotted for 2 weeks at most. So we're in day 36. Oh, I know. It's a lot at once, and I can't help the courts. So what we're going to do, we'll be watching Karen Reed when she gets into trial during the day. At night, Lori Daybell, and we'll fill in the breaks on the Karen Reed trial if Monica Simatilli's still going. I don't think they will be. Hopefully they're getting close to the end. Because it may take 2 weeks to get a jury for Karen Reed. We'll see how it actually ends up flowing. Okay. So what I'm going to do, y'all are going to love me. Y'all are going to love me or you're going to hate me. Inner studio. I'm going to start this live. Y'all, this is a lot. How I'm keeping things straight. It's been crazy. It's cray cray. It's cray cray. It's cray cray. Okay, I don't need that. I'm going to put that there. Like that. Okay. So I'm going to start the live for the Monica Simatilli trial. Let's get that going. God help us. Then I'm going to teleport y'all. Oh, first I got to do that. So it is a little crazy. By the way, the volcano in Iceland erupts while tourists are there. Ah, that's horrible. That's horrible. Okay, I'm gonna get this up and going, guys. And then I'll call you up. But thank you guys so much for joining me. Appreciate you. You're amazing. Okay, guys, love and appreciate you. We're gonna pause this right here. We'll save it. We're going over to Monica Simatilli, who is starting in a few minutes. If Karen Reed comes back, we'll hop back in. Okay? See you. Thanks for joining me. Miguel. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.